Pliska v. Latier, file 25-9181CK. We have plaintiff, Mr. Pliska, present in the courtroom. His attorney, Mr. Engelson, is appearing by Zoom video. We have counsel for defendant. We have a defendant, Ms. Latier, present in the courtroom, as well as her attorney, Mr. Mark Connolly. Good afternoon, everybody. And this is, we're here for, we had a pretrial notice up, but also there's a motion for summary disposition that the defendant has filed, and the plaintiff has filed a response essentially acknowledging the deficiency of the complaint as the unrepresented plaintiff had filed it, and pleading with the court for an opportunity to amend it to come into compliance with the court rules. So given that background, Mr. Connolly, go ahead and argue your position.
Thank you, Your Honor. As noted throughout my motion, as it stands, the plaintiff's complaint comes nowhere near the requirements under the court rules that would show that it is sufficient for pleadings in the state of Michigan. I think that is clear. I don't need to go through that in its entirety in terms of looking at it on its face. For those reasons alone, the complaint should be dismissed. But as the court, I know, has read through my motion and brief, even if the plaintiff was given an opportunity to amend the complaint, the facts that were to come out in this case would still not amount to a claim of action. As noted, and I know as the court is well aware, this case comes because of a long meretricious relationship between the parties. There was never a marriage, never anything in writing to establish the claims that Mr. Pliska brings before the court. And as I noted, but what I wanted to certainly stress today in terms of what the Michigan case law says in regards to meretricious relationships, of course, its basis is because back in 1957, the state abolished common law marriages. So in order for a party to be to prevail in a complaint against their prior boyfriend, girlfriend, whatever label, they have to show independent additional consideration, whether that be expressed or implied, in order to do so. And it makes sense. The law does not allow for scorned lovers who didn't take the opportunity to get married to come and clog up the court systems with something exactly like what Mr. Pliska has filed before the court. And you can't use quantum merit arguments or unjust enrichment arguments either, which also makes sense, because you have to be able to show that at the time the alleged work that Mr. Pliska is alleging he needs to be paid for, at the time he was doing it, he expected to be paid. And at the time he was doing the work and expecting to be paid, my client, Ms. Latier, knew of this independent agreement and was expecting to pay him. And that there's no facts, this record will never develop in a way to show that that was ever the case. As we went through and noted in the affidavit that Ms. Latier signed and we attached to our brief, I mean, we're going through all these thieves of metal roofing, windows and doors, insulation, electrical wiring, drywall, plumbing. Those are not thieves, as Mr. Pliska wrote. Those were materials that were bought solely by Ms. Latier and put into her home. And again, then he gets into what apparently would amount to contracts that were breached by Ms. Latier, but there's nothing that will show that that was ever the case. And now, since we filed my motion back in the beginning of January, and Mr. Pliska hired Mr. Engelson, and they responded, they didn't respond with any of these potential arguments or excuse me, agreements that would help their position. Because again, that just goes to show that there are none. And if this case is allowed to proceed, none will be shown later on down the road. So essentially then, Mr. Engelson's asking the court under 2.118 to amend, obviously after the 14-day by right, so asking for leave. And I know the court is well aware of what the case law says when asking for that justice must require that be allowed. And clearly this is not one of those situations. This is clearly a futile attempt. According to the case Gagne v. Motor Parts Federal Credit Union 192 Mishap 74 on page 78, an amendment is futile where ignoring the substantive merits of the claim, it is legally insufficient on its face. That's precisely what we have here. And Mr. Pliska should not be allowed to use the court system, our civil system in this manner. And he should know that going and filing a complaint that looks like this has consequences. And those consequences are that he doesn't get to come back later and try to clean it up. He doesn't get to come back later and throw more things at the wall to see what sticks. Because ultimately the only person that's literally paying is Ms. Latier. As noted, I know there's quite a lot of different arguments that I've made, different requests that I've made, but again, this case should be nipped in the bud right now. It should be dismissed with prejudice. It should be deemed frivolous by the court, and Mr. Pliska should be on the hook to pay for Ms. Latier's costs and attorney's fees.
Can I ask you, in terms of, I mean, as I understand it, Mr. Engelson is relying on the rule, not so much of leave to amend, the normal leave to amend, but the summary disposition rule that says if I agree with you, as seems everybody agrees, that the complaint as filed was inadequate and summary disposition should issue. The court rule does say that if I'm going to enter summary disposition, I should allow the party against whom that's entering an opportunity to amend the pleadings, unless doing so would be futile. And what am I to make of the fact I'm sympathetic to your arguments that the claims for an interest in the property are at best going to be a stretch and a very difficult burden for Mr. Pliska. But Mr. Engelson's response also says he wants to press claims for a return of items of personal property, almost like a claim and delivery. I mean, that wouldn't be futile, would it, to allow for that?
Your Honor, thank you. And I apologize. I meant to address that too. I've already acknowledged that with Mr. Engelson. I've talked to him about that. I don't think that there's much. I know Ms. Latier has certainly said that there's a couple of items. She doesn't want that stuff at her house. Those are certainly things that we can do outside of the litigation realm to get him his stuff back. It's not much, but certainly, again, she doesn't want it at her home, and that can be done so without this process and without Ms. Latier having to spend thousands of dollars in attorney's fees to do so. But yeah, but honestly, I was slightly confused by some of the response in that the real property, again, that ship has sailed. The law is very clear on that. Proceeds divided, that's not allowable. That's not what the law says. They were never married. But anything in regards to personal property, I just don't want the court to allow amendment just for that without some sort of severe sanction or, very precise language on it, because again, she's had to spend a lot of money and then will continue to have to spend a lot of money on what I certainly see as a frivolous claim.
All right, thank you, Mr. Conley. Mr. Ingleson, what's your response here?
Briefly, Your Honor, the affidavit we filed it has components contrary to the affidavit filed in the pleadings filed by counsel. Whether it's a claimant
Hang on a second. Hang on a second. Hang on, you're breaking up. We're not getting a great connection here.
Sorry.
Maybe go slower.
You hear me now?
Yeah, I think we might do best if you go slowly.
I'll back up to the beginning. First of all, our response included an affidavit in opposition to the affidavit of the defendant as to the comments about personal property. There is a disagreement as to what Ms. Latier claims is being hers and what Mr. Pliska claims to be his. Now, certainly in any litigation, if a resolve can be reached, we're all for it because by and large that does occur statistically. That's part of it. The second part of it is the issue of whether or not a authority to either amend the complaint or a dismissal without prejudice, which would afford the plaintiff to file a cleaned up claim, as long as it's not futile, the law would support that proposition. And that's what we're seeking, Your Honor. Our affidavit includes the assertion that there's verbal and written agreement between the parties as to the long-term ownership of the real property. And since they're not married, should a finding be made of ownership, it would likely be in under the auspices of tenants in common, which, of course, under the partition statute, for example, would afford the opportunity in one manner or another for a division of the property or a division of its worth or a sale of it and a division of the proceeds. And so I'm the first to admit, as I did in my pleadings, Mr. Pliska's effort to bring a claim was, how should I say it politely to him and to all of us, a mess. But I don't think that should foreclose his opportunity across the board and for all time to have his opportunity. And that's what we seek. However, the court would choose to have that occur because I've offered what I believe are the options available to the court, and we seek one or the other in order to take a better, more focused approach to advancing claims on behalf of Mr. Pliska. Thank you. I'll answer any questions.
Okay, thank you. Mr. Connolly, any rebuttal argument?
Yeah, just simply, Your Honor. I mean, what I certainly want to stress to the court too, which can be gleaned, although very difficult to read through the complaint. Real property is not mentioned in this at all. I mean, he didn't write in here anything about, I somehow have some stake in this real property in Wolverine and need to be paid back for that. So now we're getting into the realm of something completely different. So and then in regards to these personal property, that's what I've addressed and individually gone through, and Ms. Latier signed the affidavit about. So if the court was to dismiss this case with prejudice based on this futile complaint, this frivolous complaint, then it would still have, they would still have this opportunity if they were to want to come back to make some argument about the real property, because, which again, of course would argue would fail, but there's nothing in here about that. So now if we
Right,
don't.
the only one that I'm stuck on is the final page of the complaint where he says theft of tools, trailers, scaffolding, and ladders. That it seems that although that was inartfully worded, giving some kind of opportunity to amend, to press a claim for conversion or claim and delivery or something. I don't know why I would be allowed to foreclose that.
And glad you brought that up, because that's what I was alluding to with what I've already, those are the only items that we believe are still on the property that, here you go.
Right, I know, but
I understand.
but if you don't do that, and I've entered summary disposition without an opportunity to amend to it, then he's without remedy.
I understand that. I completely get that from the court's perspective. So if it is very narrow to that, that's what we would certainly ask.
All right, well, here's what I'm going to do. There's a motion to dismiss this case under the court rules for summary disposition under MCR 2.116C8 and C10 for failing to state a claim on which relief can be granted, and that there's no genuine issue of material fact, and that the plaintiff the defendant, I'm sorry, is entitled to judgment as a matter of law. The complaint that the plaintiff filed representing himself is in gross violation of the court rules. It in form and in substance, even leaving aside any of the grammatical challenges in it and putting the best light in it, it is still grossly violative of the court rules, facts, and law. And it seems, you know, the way that it's just paints with such a broad brush, ignoring legal doctrines that many of these things are just simply not recoverable because these parties weren't married and they didn't have contractual agreements with each other for these services. It does seem designed to harass the defendant. So therefore, summary disposition is entirely proper, and I would grant the motion for summary disposition under MCR 2.116C8 for failing to state a claim on which relief could be granted. And the defendant, I'm sorry, the plaintiff, now represented by counsel, wants an opportunity to amend the complaint, which I'm required to do unless doing so would be futile. I find that an amendment regarding these failing to pay for services would indeed be futile. These parties were in a relationship together and residing with each other, and Mr. Plisko was doing work at the house, and now he complains, we have lost Mr. Ingelson's connection is bad. Second here. All right, I think he's connected partially. Well, I think since I'm not receiving arguments of counsel, I could just proceed with announcing my ruling, and Mr. Ingelson can obtain a.
I'm here now again, Your Honor.
Okay, very good. All right, so I'm granting motion for summary under C8. I find that, I furthermore find, before I get into amendment, it's of course unusual that a court would make the finding that a complaint was frivolous, although in this case, my ruling on the C8 motion makes clear that this was an entirely frivolous complaint, grossly violative of the court rules and of law, and I believe it was designed with an intent to harass. I find that it is clearly frivolous under MCL 600.2519, and I would award attorney fees payable by Mr. Pliska to the defendant. Mr. Connolly, you will have 21 days. Well, I'm sorry, 14 days to file a bill of costs.
Okay.
14 days after entry of the order, I suppose, because we're going to have a couple orders here. 14 days after the order of dismissal to file a bill of costs. Mr. Pliska, the plaintiff would have 7 days after you file that bill of costs to object to it. If there's no objection, then the award will enter. If there is an objection, I believe under the case law, I have to schedule it for an evidentiary hearing.
Yep.
As to amendment, I do find that an amendment regarding the property or the failing to pay for services provided would be futile and frivolous, so I'm not going to allow that. I would allow an amendment on a very limited purpose, and that would be that it would not be futile. I can't find that it would be futile to allow an amendment to pose a claim for conversion, what was called theft in the original complaint as to the personal property. So the plaintiff will be allowed 21 days after the order granting summary disposition to file an amended complaint that would be limited to claims pertaining to the alleged theft of the personal property. If the plaintiff elects not to do so within that 21 days, then the summary disposition will just be a final order. So Mr. Connolly, is that ruling clear enough for you to prepare an order to that effect?
I do think so, Your Honor, but to be more specific, because there aren't numbers, as the court noted before its ruling, would it just be
Theft of tools, trailers, scaffolding, and ladders. That is the only claim that an amendment is allowed. And so maybe if you guys sort that out, maybe the plaintiff won't want to amend. I have no idea, but he's got 21 days from the entry of the order of summary disposition to do that.
Yeah, may I be allowed to say anything?
Well, you have an attorney to speak for you, sir.
Well, she's perjured herself many times. She says she paid the
I
homage
told
for
you-
metal,
I
and they do
told
not
you
take
you
credit
had an
cards.
Attorney to speak with you. Say another word and I will hold you in contempt to spend some time in the jail. All right, we're done here today.
Thank you, Your Honor.
All right, that's contempt of court, 24 hours in the Springfield County Jail right now. Direct contempt of court for swearing as he's leaving the court proceeding. I'll enter a judgment of contempt. It'll go with the bailiff. You'll be released at 2:30 in the afternoon tomorrow, sir. All right, Mr. Engelson, you have a great day.
All right, thank you. Sorry, Your Honor.
No worries. That wasn't you.
Understood.
Let's go off.